Hi, I'm Darlie Twitty. I'm a litigation attorney here with Melone Hatley. And today, in this special Father's Day edition, we are here to talk about dads. So, specifically, dads with custody and visitation issues that they might be facing. I'm going to talk today in this video about some common struggles that dads may face going through negotiating a custody and parenting time agreement or litigating such in court, and some strategies to help you that you might not have thought about, and some mistakes to avoid. So stick around if this pertains to you for our special Father's Day edition. You might have heard about custody and visitation, but there's actually two different types of custody. Custody can be legal, which is who is making the big decisions about a child's life. So we're talking, what religion is that child going to be raised? Are they going to be homeschooled, private schooled, or public schooled? How are they going to be treated for any illnesses that they might have? Those big lifetime decisions are made by both of the child's parents most of the time. In Virginia, the court usually defaults to joint legal custody. And what that means is that both parents are supposed to be consulting with each other and making those decisions together. That is very different from mom making a decision and then telling dad about it later. That is not joint legal custody, being informed or being put on notice. You deserve to be an active participant in that conversation, to be consulted, for your opinion to be considered, and to be part of making that decision together if you have joint legal custody. Chances are, if you're not an unfit parent and you're not totally absent and not willing to cooperate and be a part of those decisions, the court is probably going to award joint legal custody. So don't give up on legal custody and think that you don't have a chance, because you probably have a better chance at joint legal custody than you might have known. The other type of custody is physical custody. That's a little more straightforward. So that's physically, where is the child? If the child is with one parent 100% of the time and is never physically with the other parent, that is sole custody. Otherwise, you're looking at a shared custody arrangement. Shared custody can be 50-50, or it can be anything between 50-50 and 100% to 0%. There is in Virginia this thing called split custody, and that's like the parent trap, where one parent has one child and the other parent has the other child. I don't see that as often anymore, although my best friend growing up was in that situation, so it does exist. But most of the time you're looking at sole custody, shared custody, not so much split custody anymore. Visitation or parenting time are interchangeable. The courts and the legislatures in Virginia try to get away from the term visitation and use parenting time more often, but it's still in a lot of the statutes and a lot of the paperwork that we use. So it is interchangeable. If you prefer one term over the other, let your attorney know and they can draft an agreement to use that term more often. But that really is just the time that the child is with each parent. Usually visitation is referred to as the time that the child is with the non-primary physical custodian. So if mom does have primary physical custody because she's got the child 51% of the time or more, then dad has visitation. And that's just what that term is. It's just about the time that the children have with each parent. Some common challenges that I see dads face in custody and visitation disputes are kind of a catch-22, and they have to do with finances and time. So if during the marriage, when the family was one family unit under one household, say dad was the primary breadwinner and it was a mutual decision of both parents for dad to be out of the home working and financially supporting the family, and mom was a stay-at-home mom. Well, when the parties split, now dad is facing an uphill battle of, when the court looks at the factors, mom had a very active role in the upbringing and care of the child. She was probably the parent who was taking the child to doctor's appointments, to extracurricular activities, having parent-teacher conferences, things like that. She probably knows all the child's little friends' names, and maybe dad doesn't. Maybe he was working late in the office or out in the field or whatever, but he was doing what the parties agreed as a family to do and financially support the family. What dad's going to have to do is make up for that time. Once the parties split, he's going to have to realize that he's going to have to cut back on that work some, and he's going to have to get to know the teachers, take the child to the doctor's appointment, go to the extracurricular activities. Lives are going to have to change a little bit because the parents are no longer together. Likewise, mom might have to re-enter the workforce, so she's going to need that support from dad. So dad should be keeping a journal and getting to know all of these players in his children's lives that he may not have known as well because he had a spouse that was taking care of that, and that was a mutual decision. That's fine. But now you need to make up for that lost time and show the court that now that you are in two different households, you are just as capable of playing that role and meeting your child's needs. And when we look at the factor of what is each parent's role in the future upbringing of the child, and in going forward, how are you going to play that role? What role are you going to play? You can show, no, I will be an active participant with school and with extracurriculars. And look what I've already done since we separated. So if you're dealing with that challenge, that would be my suggestion, is to start getting very active and keep a record so that if you do end up in court having to show proof, you can point to the times that you took the child to the doctor or the dentist or soccer, gymnastics, whatever your case may be. On the other hand, if dad is not the primary breadwinner and mom makes more money than dad, then dad is looking at another challenge. And that is when dad is trying just to get equal time with the child. Maybe dad is the person who left the marital home and the children are still home with mom. And dad is saying, I just want equal time with my kids. I really just care about the kids. That is exactly the right attitude. You should not be focused on the money. You should be focused on the kids. But don't be short-sighted and recognize the bargaining chips and the cards that you hold in your hand and what mom holds in hers. She's probably talked to an attorney, and she probably knows that if the child spends equal time with mom and dad and she makes more money than dad, then she's likely going to have to pay child support to dad. And as unfair as it is, and as much as the courts don't favor mom over dad, unfortunately, a lot of moms, especially if they were stay-at-home moms, or if they felt like they carried more of the mental load while the parties were one family unit, a lot of moms are not going to like the idea of paying dad child support, especially if it's a 50-50 time arrangement. So knowing that strategically, here's what you can do. Don't ask for equal parenting time without giving something up. If you know that she's not likely going to agree to give you 50-50 time, if that means she's going to owe you child support, then be willing to negotiate the child support. Now, I want to be clear. Neither parent is permitted to waive child support in Virginia. It is not yours to waive. It is the child's. That child deserves to be financially supported. However, there are child support guidelines, and they are the presumptive correct amount of child support. And that presumption can be overcome. You can deviate from the presumed child support guidelines if you can show the court that that deviation is in the best interest of the children. So what I have presented to my dad clients in the past and presently is, if you want 50-50 time with your child, let's run the guidelines, show that 50-50 time would result in mom owing dad child support, and then tell mom, we're willing to do a downward deviation so that no money exchanges hands. And this is in the best interest of the child. Why? Because mom is perfectly capable of financially supporting the child when the child's at her house. She can keep the lights on. She makes sure food's on the table. They have clothes that fit them. They have the school supplies they need. But likewise, dad is also able to do that. He doesn't necessarily need mom's financial support. If both parents are able to financially support the child when the child is in their home and in their care, then maybe you don't need to exchange child support financially. Maybe a check doesn't have to go from one person to the other. If mom knows that she's not going to have to write a check to dad and get over that inherent bias that she might have, she may be more willing to agree to a 50-50 split. So that's a strategy that I would have as far as dads having to overcome an unfortunate potential bias. Not all moms are bad. Not all moms have that bias. Some may be more than willing to give you equal time. But if you, in your situation, are facing a mom who it just might not sit right with her to have to pay child support for dad for whatever reason, there are strategies that you can take and things that you can do to try to convince her or the court that you should get equal time. If this doesn't result in an agreement and you end up litigating in court, The court isn't going to be focused on who makes more money. First, the court is going to look at what is the best parenting time arrangement for these kids. And if that's 50-50, then who makes more money and how do we calculate child support is an afterthought. And if the court is hearing evidence and is wondering, why is mom putting up such a fight? Courts aren't dumb. They might know that the finances have something to do with it. But if dad, you're presenting this case and showing that you're perfectly capable, maybe you have been an active participant in that child's life up until this split and you want that to continue, or there's no reason why you shouldn't get equal time, then you present that case and chances are you're going to be able to show the court that you do deserve that equal time. I want to warn you, there are some mistakes that you can make as a dad that can be super costly. Sometimes it can feel like you're not going to win. You feel like mom's not going to agree to what I want. It doesn't matter what I do. I should just give up. Do not give up. That is when you need to come talk to an attorney. You need to let us walk you through, keep your head cool, go through the motions, do the things you need to do, and just wait for the outcome. Giving up is going to show disinterest. Mom is going to be able to point to it and show that you're not involved. You don't want that. Some other mistakes that you can make are having a temper or bad mouthing the other parent. Do not, no matter what you do not go on social media. There's absolutely no way that this can help you. You bad mouthing mom or other dad or other parent is never going to help you. And what you put on social media, you would be surprised who would turn on you and who, even if your account is private, who will leak that to mom and it will show up in court and it will do nothing but bite you in the end. So do not rant on social media, and really don't badmouth your child's other parent, especially where the child can perhaps overhear that. I often put non-disparagement clauses into agreements because I don't care if your children are 16 years old or 25 years old. No child wants to hear their parent bad mouthing the other parent. It puts the child in the middle. It's just not a good thing to do. So don't badmouth the other parent, but especially not in writing and especially not on social media. If you're a dad that is facing a potential custody and visitation dispute, or you recently split from your children's other parent, or you're thinking about it, don't wait. Come talk to an attorney now. We can help guide you. We can help put some of your worries to rest, and we can help develop strategies for you on how you can overcome some of these inherent biases and reassure you that the courts don't have those biases anymore. We can help you avoid certain mistakes and give you tips on how you can present your best case and have the best chances of continuing to be a loving and caring father, active in your children's lives. Come talk to us today. Schedule a consultation with a Melone Hatley attorney.